I can see you great. The leadership of the institution, led by Advocate Sean Abrams, the National Director and Head of NPA, his 4 deputies. On his far right is Dr. Silas Ramaite, Head of Administration as well as Office of Witness Protection. He is a senior counsel. Advocate Nomgcobo Jiba, Head of NPS. Advocate Nomvula Mukatla, Head of Asset Forfeiture Unit. Mr. Willie Hofmeyer, Head of Legal Affairs Division. Ladies and gentlemen, we really appreciate the presence of the media today. The National Director is going to address you on issues and matters that are very topical and that are in the interest of the public. He will take questions after his address. May you please come to the podium.
I would like to acknowledge the presence of my 4 Deputy National Directors of Public Prosecutions. I would also like to acknowledge my Directors of Public Prosecutions that are present, as well as the Special Directors that are present, and my advisors. Similarly, I'd also like to acknowledge the members of the National Prosecuting Authorities that are present here today, and of course, most importantly, members of the media. I'd like to acknowledge you as well. Ladies and gentlemen, good morning to each and every one of you. It of course has been a while since I've called a media briefing. I was far too optimistic when I, inter alia, stated on the 7th of July 2015 that I intend engaging the media fairly regularly. I think I may have said every 6 to 8 weeks, circumstance permitting to do so. I'm not sure if Stephen Groothuis is here from Talk 702. Is he here? Stephen, thanks for reminding me. It is comforting to know that I have a spokesperson in Advocate Levuyo Mfaku, who has done a tremendously great job in representing me in speaking to the media in the last 11 months. I thank him for his very valiant efforts under extremely difficult circumstances. I do, however, intend to engage the media when I deem it necessary, as I had done occasionally last year and as I had done Monday a week ago when I spoke out against the hype surrounding the reported rumors of the imminent arrest of Finance Minister Pravin Gordhan. This year marks the 20th anniversary of our Constitution. Since the birth of our democracy, we have been fortified by the rule of law and the Constitution, which is paramount to sustaining and developing our very young democracy. That being said, prosecutors are enjoined by the Constitution and the rule of law to deliver a service to society without fear, favor, or prejudice. I have on numerous occasions emphasized the significance of prosecutorial powers and discretion, which has the ability to not only change the lives of both alleged perpetrators of crime and victims of crime, but that of the very societies within which we live and work. I cannot sufficiently overstate that such powers and discretion must be exercised with the greatest degree of responsibility and due cognizance of the rule of law, constitutional values, and the integrity and responsibility of the very noble office prosecutors hold. As a people, we must resist the temptation to trial, convict, and or acquit people in the court of public domain. It only contributes to speculation and unnecessary instability in both the National Prosecuting Authority and in our country. At times, it critically impacts negatively on the economic, political, and social stability of our country. This wades public confidence in the administration of justice and critical institutions enjoined by the Constitution to strengthen and protect our very young democracy. The media, of course, plays a critical role in this regard and in balancing ethical and responsible reporting along with the public's interests and the public's right to know, too, must take responsibility. I would like to address two matters today. The issue around the reported imminent arrest of Finance Minister Trevor Gordhan and my decision in respect of the judgment by the full bench of the Pretoria High Court in respect of what the media have dubbed the spy tapes matter. I am not a politician, and I have no interest to be one or to be embroiled therein. I am also not an economist, nor can I ever profess to be one. This country, what impacts on it, and the public interests, do I ever call for my intervention when same is required. I called for this briefing today because it's in the public interest to do so. Last weekend's media reports of the imminent arrest of the Minister of Finance, Pravin Gordhan, along with other senior government officials, past and present, negatively affected the economy and the political and social outlook of the Republic. Persistent, speculative reports of the so-called imminent arrest of the Minister of Finance and speculative comments thereof for the duration of the week, including right up until yesterday, by certain sectors of the media, comments from certain politicians, certain economists, and certain legal writers and or commentators did not make the situation any easier, but instead inflamed an already escalating volatile and gloomy political, social, and economic outlook for the citizenry of our very young democracy. On Monday, a week ago, following the weekend media reports, I deemed it prudent to entertain one-on-one media briefings during which I communicated the position around the investigation conducted by the Directorate for Priority Crimes investigation into what the media has described as the SARS rogue unit. Despite my efforts to quell the rumors, which were widely publicized by E-News, SABC News, ANN7 News, Cape Talk, and which print and electronic media selectively later commented on, sectors of the media, politicians, legal commentators, and economists persisted with unwarranted and speculative reports of the imminent arrest of the Minister of Finance, Pravin Gordhan. Many things have been said, and aspersions cast on key institutions established to strengthen this democracy. I can only talk on behalf of the National Prosecuting Authority. I don't want to involve myself with the political issues around this matter, nor to allow this institution to be pulled into such a space. I, however, deem it prudent to make it abundantly clear neither I nor the institution require the political go-ahead to prosecute anyone. I don't need any politician or any person's permission to institute a prosecution against anyone. There is no person or entity on this earth that can influence me in making any decision. The NPA is not involved in, nor is it driving any prosecution in this matter, nor is it involved in any principled objective to remove and punish anyone. The NPA is not filthy or corrupt, as some politicians and others would want you to believe. We do, however, strive to rid the NPA of officials who fall within that category of people. The NPA is not, as alleged in some quarters, conniving, nor is it collaborating with any persons in any other institutions in this matter, nor in any other matter, as some people would want you to believe. The NPA is not involved in the so-called removal of officials from other institutions, as some people would want you to believe. There are some people that want you to believe that their removal from office was as a direct result of them working on similar identified cases. I am looking at these very same cases. At present, I am still in office. I hope to make decisions in respect of some of these matters in the very near future. The NPA is not involved in subjecting anyone to the manipulation of the law, or is it a party to any ulterior motives. The NPA is not conspiring with anyone to intimidate and harass any person or persons or their families, nor is it independently subjecting any persons to arrest and intimidation. There is no person or business person that can claim to have any inside knowledge or influence over me or of the NPA. The NPA is not involved in any unrestrained attack on any person, nor is it involved in any subversion of our young democracy, as some would have you believe. There is no evidence remotely that has been brought to my attention, nor to the attention of the National Prosecuting Authority, that the investigation of the SARS road unit is politically motivated. The investigation concerned is also not unconstitutional or unlawful, as some would have you believe. The powers of the DPCI and or the Hawks are legislated and clearly defined. In terms of Article 8 of the prosecution policy, effective cooperation with the police and other investigative agencies is essential to the efficacy of the prosecution process. In cases where difficult questions of fact or law may arise, it is desirable for the police to consult with the National Prosecuting Authority before arresting or charging suspected persons. A prosecutor's involvement may also be continuous, and prosecutors may issue specific instructions to the police, which the police must comply with. This is in order to establish whether the evidence is reliable and admissible, and whether there are reasonable prospects of a successful prosecution, and also whether it's in the interest of justice that such a prosecution must proceed. In terms of Article C, subsection G of the Code of Conduct for members of the Prosecuting Authority, prosecutors should perform their duties without fear, favor, or prejudice, and should particularly take into account all relevant circumstances and ensure that reasonable inquiries are made about evidence, irrespective of whether these inquiries are to the advantage or to the disadvantage of the alleged offender. I further wish to make the following emphatically clear. There are no charges of espionage being investigated against Minister Godhan. There are no charges of espionage being investigated against any other person associated with what the media has dubbed the so-called SARS road unit, namely the SARS high-risk investigative unit. Although the Special Director of Public Prosecutions, who heads the Priority Crimes Litigation Unit, would ordinarily make his decision in consultation with the Director of Public Prosecutions concerned on whether or not to prosecute. In this matter, the Special Director concerned will, in consultation with the Director of Public Prosecutions, make a recommendation to me on whether or not any person should be prosecuted. In the event that the minister is implicated, I will make the decision at the conclusion of the investigation as to whether or not any person or persons must be prosecuted, including the minister. The DPCI is not obligated to disclose to anyone who their suspects are, nor what crimes they are investigating. It's absolutely unheard of. It is not in anyone's interest for this matter to be investigated in the public domain, for all and sundry to suddenly become experts and to comment and advise thereon in circumstances where all the evidence is unknown to such person, nor is the evidence at his or her disposal. In the event that the evidence implicates any person of having committed a crime, a warning statement will be obtained from the person in respect thereof, during which he or she will be afforded an opportunity to respond to any criminal allegations, or he or she can of course elect to remain silent. At that stage, the person will in no uncertain terms be informed that he or she is a suspect. A decision on whether or not to prosecute any person in respect of this matter will only be made thereafter. Although the powers of arrest are within the purview of the South African Police Service, I can assure you that under my authority, no person, including Minister Gordhan, will be the subject of any arrest or charges being preferred against them in this matter. I implore you to respect the process of the investigation until its conclusion, along with any decision thereafter as to whether any person must be prosecuted. I will certainly take the interests of the public into consideration when called upon to decide on this matter, like I do in respect of every other matter. However, the prosecution policy requires prosecutors to, at all time, act in the interests of the community and not necessarily in accordance with the wishes of the community. The matter is not on my desk. It will only make its way to me once the investigation has been concluded and a recommendation thereon made to me. I call upon all concerned, including the media, politicians, legal commentators, and economists, to stop playing with our economy and stop deriving political mileage out of this matter or any other matter. People should not be tried, acquitted, or convicted in the court of public opinion. The NPA is constitutionally and legislatively empowered to decide who should or who should not be prosecuted. Unfortunately, there are too many today who try to usurp the NPA's position. For instance, as you may well know, the NPA is faced with people, including certain politicians, sectors of the media, sectors of the public, and certain legal commentators who, on the one hand, call on the NPA not to prosecute Minister Gordhan, but on the other hand, the same people call for the prosecution of President Zuma. These are matters which must be left to the NPA. I cannot imagine a day when the prosecuting authority exercises its responsibilities, legal and constitutional mandate through the dictates of public and of political sentiments or wishes. On 18 May this year, a cartoonist for the Herald depicted me seated in the sidecar of a motorcycle driven by what is purported to be President Zuma. Seated behind me is Minister Pravin Gordhan holding a very fearful-looking rand. the cartoonist quotes me as saying, "There's no one in this world who would influence me to make any decision." The caption at the foot end of the cartoon reads, "Hawks investigating Gordon. Which way will Abrams go?" It's of course very premature to ask this question. But I can assure you, as I stand before you today, I am not a passenger in anyone's vehicle, and I never will be a passenger in anyone's vehicle. This, of course, takes us to the real reason why we're all here today. A few weeks ago, a Business Day cartoonist depicted me on a very tiny little scooter, purporting to be stationary at an intersection with only 3 choices to make: to turn left, to turn right, or to proceed straight ahead. I must, however, give credit to the cartoonist for his almost accurate depiction of my eyebrows. But before I go ahead, is Mr. Abraham Mashego from City Press here? Where is he? Is he here? Is he hiding away from me? He's hiding from me. I was going to invite him to come and address you. He seemed to have some not so correct inside information that he published yesterday in the City Press. No wonder he's hiding. Yeah. I was appointed as the National Director of Public Prosecutions by the President of the Republic in terms of Section 179(1) of the Constitution, read with Sections 9, 10 and 12 of the National Prosecuting Authority Act on the 18th of June last year. It is imperative in terms of the Constitution that the prosecuting authority must exercise its functions without fear, favor and prejudice. This obligation is repeated in Section 32, subsection 1A of the National Prosecuting Authority Act, which reads, open quote, "A member of the prosecuting authority shall serve impartially and exercise, carry out, or perform his or her powers, duties, and functions in good faith and without fear, favor, or prejudice, and subject only to the Constitution and the law." Close quote. Section 32, subsection 1B of the NPA Act further reads, open quote, "Subject to the Constitution and this Act, no organ of state and no member or employee of an organ of state, nor any other person shall improperly interfere with, hinder, or obstruct the prosecuting authority or any member thereof in the exercise, carrying out, or performance of its of her power, duties, and functions." Close quote. In terms of Section 20, subsection 1 of the National Prosecuting Authority Act, which is echoed by Section 179, subsection 2 of the Constitution, open quote, "The power as contemplated in Section 179, subsection 2 of the Constitution, and all other relevant sections of the Constitution to A. Institute and conduct criminal proceedings on behalf of the state, B. Carry out any necessary functions incidental to instituting and conducting such criminal proceedings, and C. Discontinue criminal proceedings, vests in the prosecuting authority, and shall, for all purposes, be exercised on behalf of the Republic." Close quote. It is well known that on 6 April 2009, the acting National Director of Public Prosecutions at the time, Advocate Mshe SC, announced his decision, taken on 1 April 2009, to discontinue the prosecution against Mr. Zuma, who was President of the African National Congress at the time, but not yet President of the Republic of South Africa. Whilst I was a member of the NPA at the time, I was neither involved in guiding the investigation, the decision to prosecute, nor in the decision to withdraw the charges. I came to know of the decision when the general public was so informed on 6 April 2009. On 29 April 2016, the full bench of the Pretoria High Court set aside the decision of Advocate Moshe of 1 April 2009 to discontinue the prosecution of the case against Mr. Zuma in accordance with the indictment served on Mr. Zuma on 28 December 2007. The effect of the decision of the High Court is that, absent an application for leave to appeal, it falls upon me as the National Director to consider the matter. I have read the decision of the full bench of the Pretoria High Court, and I have considered whether it is a matter where application for leave to appeal to the Supreme Court of Appeal, and if there are grounds to do so, should indeed be brought. I have taken legal advice from senior counsel and junior counsel and from senior members of the National Prosecuting Authority, particularly in regard to the High Court's findings and the bases thereof. I regularly read print and electronic media reports, and when time permits, I listen to radio, and I too watch television broadcast news. It would be naive for anyone to think that I am not aware of the calls from certain sections of the citizenry to proceed with the prosecution. There are, of course, equally calls that I should not do so. I wish to make it absolutely clear that I will carry out my duties and my obligations in all cases, irrespective of who the suspect is or who the accused may be, without fear, favor, or prejudice. I will only do so in what I believe is correct and proper in fulfilling my constitutional obligations and those imposed upon me by the National Prosecuting Authority Act and any other law. In the present matter concerning President Zuma, whatever decision I make will no doubt elicit criticism from some or other quarters. No decision will please all of the people, yet it is not in my job to seek to please anybody or make popular decisions, but only to act in terms of the principles and policy and in accordance with my constitutional and statutory duties. I will always do what is correct, irrespective of whether the individual concerned is an ordinary citizen, a cabinet minister, or a sitting president, and regardless of the person's station in life. If there is any suggestion that I may have succumbed to any pressure in making my decision, I can assure the public today that it's absolutely ridiculous and completely unfounded. My decision has been made after much consideration, consultation with senior members of the National Prosecuting Authority, and after obtaining legal advice from senior counsel. The High Court found that Advocate Mshe, the then acting National Director of Public Prosecutions, should not have taken it upon himself to discontinue the charges in light of the prosecutorial misconduct. The High Court found that Advocate Mshe should rather have allowed the issue to be ventilated in court. This means that the head of the National Prosecuting Authority may not take it upon himself or herself to determine that the abuse of process was so egregious as to warrant discontinuation. The National Director has, after all, taken an oath to protect and defend our Constitution. The National Director's duty is to protect the institution and integrity of the Constitution. It is the National Director, I believe, who is best positioned to weigh the seriousness of abuse within his or her own hierarchy. If, as here, the National Director misconducts himself or herself in the internal review of a prosecution, it is always open for the matter to be taken on review. Sight must not be lost of the tried principle that a prosecutor is vested with a very broad discretion. The public interest, and not the wishes of the public, must always factor in his or her determinations to the extent that it is not obligatory that every person the prosecutor considers guilty must be charged. Nevertheless, the High Court has decided that where there was misconduct, as in the present case, the present matter should have been taken to and argued before court. In my view, if this is now general principle, then prosecutors are denuded of much of their powers. Article B of the Code of Conduct for members of the National Prosecuting Authority reads, open quote, "The prosecutorial discretion to institute and to stop criminal proceedings should be exercised independently in accordance with the prosecution policy and policy directives and be free from political, public, and judicial interference." Close quote. In terms of Article 3 of the prosecution policy, the prosecutor has a discretion to make decisions which affect the criminal process. This discretion can be exercised at specific stages of the process. In principle, the judgment also affects each and every person who is the subject of a prosecutorial consideration, and the discretionary powers of the prosecutor, which is exercised on a daily basis and at various stages of the process. The judgment of the full bench of the Pretoria High Court is also a matter that seriously affects the separation of powers. This is an important matter of principle which affects all prosecutions. It is so important, I believe, it needs the decision of an appeal court. It has far-reaching ramifications for the powers of the institution and for the very citizenry of our republic and our young democracy. Whilst the issue arises in a high-profile case, it is the only decision on this point, and I believe, with respect to the High Court judgment, that it should be considered by an appeal court. I should mention that this, of course, is not the exclusive ground upon which leave to appeal will be sought. In the circumstances, as appears from what I have said, I have decided to apply for leave to appeal against the judgment of the full bench of the Pretoria High Court. There is considerable public interest at stake herein, and the issues are of great constitutional import. I have instructed the State Attorney to file the necessary papers this morning. As I stand before you today, I reassure you of my commitment to my oath of office to uphold, protect, and defend the Constitution and the fundamental rights entrenched therein, and to enforce the law of the Republic without fear, favour, and prejudice, and to do so vigorously as the circumstances of any particular case may require, and in accordance with the Constitution and the law. I thank you.
Thank you, National Director, for the comprehensive briefing. We said initially we're going to engage, but before we engage, let me articulate the fact that the National Director is required in terms of Section 35, 2A of the National Prosecuting Authority Act to compile a report that would be tabled by the Minister of Justice in Parliament, reflecting on the high-profile cases as well as the work of the NPA. So we will invite you, members of the media, probably during the second week of June for such a briefing. Therefore, we do not expect you to raise any issue relating to any matter that was not articulated today. Confine yourselves to the issues that were articulated in respect of the so-called SARS rogue unit as well as the spy tapes. Further to that, we are not allowed to engage on the merits of any matter. The National Director quoted extensively the provisions of our national policy directives that prohibit us from engaging on the merit of a matter that is still subject to investigation or that is pending in court. We will therefore not take questions on the merit. We've got, I hope it makes sense. we've got 2 roving mics. You know the drill. You raise your, by show of hand, we'll take first round 5 questions. Where are the mics? Are they ready? I don't see any hands. No, allow.
I don't know if this is on. Is it on?
It is on.
Thank you. Karen Morn from ENCA. In your grounds for seeking to appeal the spy tapes ruling, you've said that this is essentially an issue of independence and separation of powers. Given that you seem to be raising constitutional grounds, will you be applying for direct access to the Constitutional Court? Because as I'm sure you're aware, many will view this appeal as a potential delaying tactic. And if it isn't, would it not be better to go straight to the Constitutional Court and have this matter resolved as clearly as soon as possible? Second of all, in your critique on the Gordhan matter, is it not incredibly unfortunate that the basis of the story was in fact the apparent leak of the Hawks' questions to the finance minister, to the media? Because it seems to be that there were definitive forces in the leaking of that story from governmental sources, and particularly the Hawks, that seem to have fueled it and fueled the instability and the aspersions on his character. Thank you.
Thanks, Karen.
Go ahead.
Okay.
Okay. Good morning, Aldrin Sampier from SABC TV News. Just 2 quick ones. Did you at all, President Jacob Zuma is a respondent in this matter. Did you at all have a discussion with his legal team with regards to the decision that you have taken, or even before that decision was taken? And have you ever spoken to Mkotari Mpse about the decision that he had taken at the time, and what led to that decision, and whether you still believe that the decision was right? And I think that's something that did not come out of this press briefing, whether you still believe, or whether the NPA still believes that the decision taken back then in 2009 was a rational decision. Is that still your conviction based on the arguments in court as well?
Do we have any other question? We seem not to have questions. I'll call the National Director to address the questions that were raised.
If you actually saw my handwriting, you'd realize why I've got to write so carefully. I barely struggle to read my own handwriting. I think let me start off by responding to the questions from Karen Morn. We did consider the approach of direct access to the Constitutional Court, but we felt this is a matter of such significance and importance that we must show confidence in the Supreme Court of Appeal, and that's why we've adopted this route. So it was never a situation of attempting to delay this matter. That was the furthest consideration. In fact, it didn't even come into consideration at all. So I categorically deny that there's any attempts from the NPA to try and delay this matter. Regrettably, I cannot comment on any leaks that derive from anywhere. Remember, this is a matter that was submitted to the NPA a number of weeks ago. So the National Prosecuting Authority was not involved in any questions that were submitted to Minister Pravin Gordhan. So any leaks that are associated with this matter throughout this investigation has nothing to do with the NPA. So I cannot comment on it. I think it's a question that should probably be posed to the Hawks or anybody else, but we can't comment thereon. I did not have any discussions with the legal team of the President in respect of this matter. I did not discuss, or should I rather say, at the time the decision was made, it was never discussed with me by Corkium Share. So we've never had this discussion then, and we've never had that discussion now. My consideration at this stage is strictly limited to the judgment of the full bench of the Pretoria High Court. I am not prepared to comment on the merits of the matter. I'm not prepared to comment on the factors that Advocate Corkium Share SC took into consideration at the time when he made a decision. Thank you.
Thanks, NDPP. Any other questions? Barry Bateman, and there's a gentleman at the back that I've noted. Where's the other roving mic? You must go closer to that gentleman. Yes, Barry.
Good morning, Advocate Abraham. Barry Bateman, Eyewitness News. In reaching your decision to choose this route of appeal, did you consult Prosecutor Downer or any of the legal teams on perhaps their input on whether they felt that this was the correct route to be taking? And if not, why not? Thank you.
There's a hand. No, start with that.
Angelo Coppola from China Central Television. You mentioned that the grounds that you gave now were not exclusive grounds only. What other grounds are you basing your appeal on?
Karen? Oh, Polly?
Good morning. I'm Polly van Wyk from Media 24. Can you take us in your confidence and tell us who you did consult with? You mentioned SCs or senior counsel, and you also mentioned junior counsel.
The question that was raised at the back, and Barry Bateman, it borders on the merits. This is not about the merits of the case. It's about the review of a civil application. I don't think you expect the National Director to dwell too much on your issue, but I'll allow him space to respond.
Thank you. Let me start off by responding to Barry's question. Barry, I did not consult Advocate Billy Downer, SC, nor any other members of the prosecuting team. I didn't think I needed to do so. And I still don't think that I needed to do so. There was a question as to who I consulted. I don't have to disclose to any person or to the public which legal counsel or which members in the NPA that I consulted with. I think that's absolutely improper. But what I can confirm is the legal team that represented the NPA during the arguing of the matter before the full bench of the Pretoria High Court was consulted thereon by me, and by me only. What are the grounds that we rely upon? Well, I've given instructions to the State Attorney, and he's going to file this document, or he probably has filed it as as I'm engaging with you. There are 6 grounds. Consists of 14 pages. I'm not going to go into any of them, but the document is available for your consideration.
Thank you, National Director. That will be a last round before we actually conclude. Karen Ma?
Just another question. The issue of a review of a decision not to prosecute was arguably settled in the Supreme Court of Appeal with the Mdluli matter, and the NPA chose in that matter to reinstate charges. So what is the difference with the case against President Jacob Zuma? Because in that case, the NPA accepted the court's rationale, but in this case you're saying it's a question of the independence of the NPA. So why was it not challenged further then? Thank you.
Karen, please repeat the question. Okay. Can you please?
I was asking about with the Supreme Court of Appeals ruling in the Mdluli matter, which found that the decision in that case not to prosecute was irrational. The NPA did pursue the murder case against Richard Mdluli. I don't know what the status is of the corruption case, but if this is a question of reinstating charges and that kind of issue, why was that case not challenged further? Because you seem to have accepted what seems to be settled and trite law in that matter, but now we're not doing it in this case. Why? Thank you.
Chief.
Sure, it's Eldrin Simpie again from SABC TV News. I'm not asking about the merits of the case per se. What I really want to find out, is it still the NPA's conviction that President Jacob Zuma will not receive a fair trial should this matter go ahead?
There is no other question. This is the last round. I'll allow the National Director to respond.
I think maybe I should first respond to the question in respect of the Mdluli matter. Of course, the facts of the two matters are completely different. And the consideration given to proceed with that matter was of course taken by considering the facts of that particular matter. So it is inherent to that matter. And we shouldn't conflate the two matters. The question as to whether President Zuma will receive a fair trial, I think it's improper for me to respond to this matter when this matter will now be the subject of ventilation by the Supreme Court of Appeal in the event that the full bench accedes to our application. So I think it's improper for me to respond there too. I trust that's in order. Thank you.
Media colleagues, thanks for honoring our invite. This concludes the presser. National leadership, you may be excused. When necessary, the National Director will take one-on-ones, when necessary.
That was the press briefing by the National Prosecuting Authority head, Sean Abrams, that have announced their response to last month's judgment in the so-called spy tape saga.